Morning. Good morning, Judge. It's Maytha here from the
Good
DIFC
morning.
Court.
Good morning.
Judge, I would like to begin, please, by reading out a statement in which I will state the name of the counsels attending today.
Yes, please do, and record that this is being heard before the DIFC Court.
Yes, it is. Thank you, Judge.
Thank you.
The hearing is in the matter of CFI 070-2018 before Justice Sir Peter Gross, and it's being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Al-Tamimi Company. Lead counsels are Sharif Shifji, QC, and Carl Anderson. The defendant's solicitor is present, so there is no counsel for the defendants today.
Right, thank you very much, Maytha. I appreciate that. Thank you.
Judge.
Right. I will proceed then. Mr. Shivji, I'm conscious you need to be away, but this shouldn't take more than about half an hour. But I wanted to get everyone together so we all know where we are, and it will save a lot of time in terms of emails. If Maytha is kind enough to keep a note of whatever orders we make, it will save time in drawing up the order afterwards.
Yes, Judge.
Now, Mr. Shivji, and I'm aware Mr. Fedrigoli is here for the defendant. I think he's here, though he doesn't have formal rights of audience. Okay, we'll see if we need to ask him anything later. The one thing I have no idea about, Mr. Shivji, is what this case is about. Are you able to summarize it in about 2 or 3 non-contentious sentences?
Yes, I am, my lord. As I mentioned, I appear for the claimant in this matter, which is a DIFC registered bank. The bank made a loan to the defendants of about $7 million US under a facility agreement, and that loan was made to the first defendant, and the other defendants acted as guarantors. Those monies were advanced. Some portion went to an entity within the defendant's group. The other portion went to what the bank understood to be trading counterparties of the defendants. None of those monies have been repaid. Originally, the bank obtained a default judgment against the defendants, but that was set aside subsequently on their application. And the essence of their defence on that application and in their defence to this action is that they are the victims of a fraud by their own employees, who they say forged the facility documents and guarantees, etc. So that really is the central issue between the parties. And as the court may have noted, that there has been quite a convoluted document production process where certain problems have arisen, and that is now forms the basis of our unless order application. But on top of that, one of the defendants, the third defendant, has issued an immediate judgment application where it says that essentially notwithstanding its allegations of fraud, it says that on the face of the facility agreement and the guarantee signed by it, the signatory was someone who didn't have authority to do so. So
Could you just say that again? So the third defendant has the immediate judgment application.
That's right. And in that application, the third defendant says that the signatory, if the signature is valid and not a forgery, so essentially contrary to its defence, it says that the signatory didn't have authority to sign that document on behalf of the third defendant, and as a result, that document is not enforceable by the bank.
Good. You can see why a case memorandum and a list of issues will be helpful. Right, now to your draft directions. Unless Mr. Fedri, what I am going to do, I'm conscious he doesn't have rights of audience, but it's a bit silly if he's here. not to see if he wants to add a sentence or two. Mr. Fedrigoli, can you unmute yourself? At the moment, you're a white circle on a black background.
Yes, I can hear, Your Honor.
Yeah, I can't see you. Do you want to come into the light? Good morning.
I'm not wearing proper clothes because I didn't expect to be to be seen.
No.
Obviously.
Well, there's a lesson in that.
I apologize.
Yeah, don't do it again if you don't mind. If you are attending at all, assume something might happen.
I apologize. I'm in my partner office.
That's all right. You're in your exercising gear, which I understand. That's not a problem. But just be careful in the future when it might matter. Anything you want to add to Mr. Shivji's summary?
No, I think the summary is quite accurate. As you probably have seen in the correspondence that we have that was provided by the claimant, we did not agree that the immediate judgment application precedes the summary judgment application, and I only note that Mr. Sharif is following that order even in his explanation. So he mentioned first the immediate judgment application, I believe, if I'm not mistaken.
Well, we'll see in a moment. All right. Thank you very much. You can stay on screen or go back into the background, whichever you prefer.
I can leave the screen on. I will need to adjust my phone, and so you can
do whatever is more comfortable, as long as you are here and can hear me. Thank you very much.
Thank you very much, Your Honor.
Mr. Shivji, let's work our way through the directions.
I'm grateful.
I'm working off your draft directions, and although the parties agree certain things, I want to look a bit more carefully at one or two of the dates.
Yes, of course.
Just to begin, I can't do the 14th to the 29th of March.
Understood.
So the choice for you is really going to be the 7th, 8th March, which I offered, but which I think gives you difficulty, or the 15th, 16th February, or it goes back, which I assume neither side wants. If it's the 15th, 16th February, which is doable by me, the key question is, will the parties be ready? I should indicate I'm going to hear both applications together. It seemed a very poor use of time not to. And I have to tell you that as far as I'm concerned, it doesn't much matter which application is heard in which order, because as long as it's a single hearing, it will be digested by me in whatever order it comes. But I'm happy with Mr. Shivji's proposed order. We start with the unless order. He introduces the case. We hear both in the course of a day and a half or so. Are you still in difficulty on the 7th, 8th March?
I am, I'm afraid. I have a hearing for the UK Financial Conduct Authority on the 8th of March before its RDC. Right.
Okay. Well, then, if people want it on in February, March, it's going to be the 15th, 16th February. Mr. Fedrigoli, you'll have to get counsel for that. Or somebody with the right voice. Okay.
Absolutely.
It's still about 5 weeks away, so there's time. But if we are going for the 15th, 16th February, then, gentlemen, we have to advance one or two dates a bit. So, working through the draft directions. First one, defendant's evidence and answer to the unless order application, 20th January, that's fine. When you give a time, I'm assuming it's UAE time,
Yes.
unless otherwise stated. So, Mather, it's 1600 UAE time on 20th January for the first direction.
Yes, Judge, noted.
Thank you very much. I'll do the same as we go through. Second one, claimant's evidence in reply for the unless order application. No, Mr. Shivji, if we're going for the 15th, 16th, I need to bring you forward a bit. I had in mind 1600 UAE time, Tuesday, the 1st February. You'll just have to get your skates on a bit.
Understood.
The third one, the case memorandum and list of issues, Mather 1600 UAE time, Monday, 7th February. The 15th, remember, is a Tuesday, so I'm trying to make sure I've got what I need. The e-bundles have to be there before the weekend. So Mather can tell me whether this is going to work. If I fix the e-bundles for, say, 1200 UAE time, Thursday, 10th February, Mather, can you get it online so I can look at it on the weekend before,
Yes,
before you break for a UAE weekend?
yes, sure. Yes, it can be arranged.
I'm very grateful. Okay, 1200 UAE time, Thursday, 10th February. Draft Direction 5, agreed. If there's anything you want to refer to, legislation, orders, rules, whatever you want, please put them in the e-bundle so I've got them in one place. 6, also agreed, covering all the previous orders in the matter. Now, 7, single skeletons, please. You can just deal with both topics one after the other. I've given you the maximum page number, which is ample. Don't, if you want to produce something shorter, there will be no objection, but just nothing longer. So 35 pages with that sort of, with a font specification is the maximum, not anything else. But now, right, how quickly can you get me the skeletons? We start on a Tuesday. I need to read the skeletons.
Understood, and it is quite complicated. So yep. We're in your lordship's hands. If your lordship tells us when you'd like to read them, we'll have them to you for then.
I'd like to read them, Mr. Shivji, Mr. Fedrigoli, on that weekend, or at least have the facility of starting to read them. But now, Mather, can you tell me if I directed the legal representatives to file skeleton arguments by, say, 0900 UAE time on the Saturday, is there anyone in the registry who can then get them to me?
Yes, Judge, I'll be available on that day. So as soon as they file it, I'll send it to you.
And that won't inconvenience you?
Yes, it's fine, Judge.
It's fine. Are you sure? Okay. Yes. Gentlemen, I'm afraid it's 0900 on Saturday, the 12th UAE time. And then I have at least a sporting chance of reading it in advance of the hearing on the Tuesday. And especially if it's complex, I can't just flip through it. I'll need to think about it. So single skeletons, in accordance with paragraph 7 as to the maximum length and so on, and delivered by 0900 UAE time, Saturday, 12th February. And then I agree, unless Mr. Fedrigoli you want to argue, but I really don't think it matters much. We start with the unless order application. We go on to the immediate judgment application. It really doesn't matter much because it's the same judge at the same hearing. And so...
Your Honor, you asked me if I intend to argue. I don't really intend to argue, but I was just wondering why would that be the order if chronologically the immediate judgment application, which is actually less complex and shorter in terms of
Yes.
of evidence, precedes the unless order application, which is.
That's a very fair question. The answer is that Mr. Shivji has explained that through the unless order application, it will be easier to explain the case overall than the immediate judgment application.
I fully disagree on that. The immediate judgment application. I actually believe that this is the claimant is taking an opportunity, or is trying to take an opportunity to make what a very straightforward application on a very narrow point, very narrow factual background, and extremely narrow points of law, and possibly to advance his arguments before those straightforward arguments are advanced, so that they will become possibly less straightforward in the eyes of the court.
It's called advocacy.
Exactly, and that's why I know it's called advocacy, but as I say, chronologically, the immediate judgment application was filed 1 month before, and unless the advocacy of Mr. Sharif is very effective, I don't see why we should reverse them and not follow the time, the chronological time, which is that cannot be changed, unfortunately, for Mr. Sharif.
Good. Mr. Shivji?
So the most important consideration is what is the most useful way of conducting the hearing of both of these applications. And the way that we intend to present both applications is together. And we've explained previously that there is a link between the two, and the defendants haven't disputed that link, and your lordship considered that link in deciding to hear both of the applications together. We say that the court needs to understand the overall proceedings as it ordinarily would do in considering an immediate judgment application by one of the parties. And there's no dispute that even if the third defendant is successful on its immediate judgment application, that the rest of the case would need to go to trial. And the court will want to understand what are the issues for trial, hence your lordship's direction for a list of issues. And we say that the unless order application is the only and best way of presenting that. So in our submission, it's simply a question of what is the most orderly way to conduct the hearing. I've explained how I intend to approach it. And the sequence in which the applications were issued just has no bearing on that question. So that's our position.
Well, one thing which may accommodate everybody's interests, your application is the unless order application. So you should open that and you have the last word in it. Mr. Fedrigoli's client's application is the immediate judgment application. So he will open that and have the last word in it. He's disappeared, but I don't think, no, there he is. So I'm going to, Mr. Fedrigoli, stick to the order I suggested for the reasons Mr. Shivji has suggested. But, so you aren't unduly concerned by it, when Mr. Shivji will open the unless order application, we'll deal with that. You can then open the immediate judgment application and you will have the last word on that, or rather your counsel will. So on that basis, it doesn't really matter, and you can, ideally, both of you will keep both applications as simple as possible. How does that work?
Thank you, Your Honor. I just wanted to know whether we will be able to allocate a specific amount of time to both applications, so that
well, that's a very good point.
So that the fact that the one is there before the other doesn't impact the time.
What I'm going to say is that you and Mr. Shivji, just one matter. You are Mr. Shivji as opposed to Mr. Sharif.
I am Sharif's my first name, but I'm happy to respond to either.
No, it's just Mr. Fedrigoli. And for a moment, I was horrified and thought I got it wrong. Why don't we do this for the timetable? You agree one between you, or your solicitors, Mr. Shivji and Mr. Fedrigoli. Don't please, I'm saying this to the parties, not to you both. Don't try and score points on the timetable. If you don't agree one, I'll impose one. And that's a pretty blunt instrument. So why don't you work on the basis that we have up to 2 days to hear it? No longer, it can't go longer. I'm relaxed about whether you want time for case management directions at the end. The reason for that is the directions may be affected by what my decisions are, which probably won't be given on the day, even though if they are, they'll be given without reasons on the day. So you can reduce that to say half an hour. But now what are our sitting hours going to be? Matha, what's the usual UAE court day?
Yes, Judge. So if it's listed for a full day, then it can start from 10 a.m. UAE time until 4 p.m. But given that you're in the UK, then we can start, if you may, at 12 p.m. until 6 p.m. UAE time.
So 12 p.m. is 0900 GMT.
Yes.
Well, let's sit. We'll work out breaks and things in due course. So it's 0900 to 1500 GMT.
Apologize for the interruption, but with the solar time, 12 p.m. Dubai time is 8 a.m.
Yes.
Okay. So it's okay. So I'm not starting at 8.
Okay,
we'll
Judge.
start.
Then, we can start at 1 p.m. It should be fine.
Okay. Thank you very much. So I'll work in GMT, so I know what I'm doing. 0900 GMT to 1500 GMT on the 15th and 16th, please. And we'll work out some sort of sensible breaks closer to the time. I'll give you a view on that. Very good. Now, by when do you think you can agree a timetable? Sooner rather than later, while today is fresh in your mind. Otherwise, I will impose one.
Should we say the end of Wednesday, if that would suit your lordship?
Mr. Fedrigoli, did that work for you?
Yeah, fine.
So by the end of Wednesday, 12th January. Okay, say 1600 GMT Wednesday. So you've got even longer in the UAE to agree that. Please, this isn't the timetable is purely efficiency. There's no tactical advantage. Both sides will have a fair chance to present their cases. Very good. If you don't agree by then, tell the registry and I will simply divide the time. But I'd much rather you did.
Yes.
And then we'll work. Good. So it's going to be the unless order, the immediate judgment application, the timetable to be agreed, build in, say, half an hour for case management directions if need be, but we'll see if we need it.
I'm grateful, but as I understand the position, your lordship's directions from today are that the unless order application, I can open the unless order application first, and then it's a matter for the parties to agree essentially how the rest of it unfolds.
How you go on, yeah. I mean, you could open that. Mr. Fedrigoli could open the immediate. I don't mind. Decide between yourselves something that makes sense. That's all I'm asking for.
I'm grateful.
Okay. Is there anything else today? Sorry, Mr. Chief.
I'm so sorry, Your Lordship. Just one minor point from us. As Your Lordship will recall, this was originally meant to be the PTR, And
Yes.
the timetable under the court's original case management order envisaged that the case would be much further advanced than it is. That
Yes.
we made, I say this without criticism of any of the parties, but we had made an application for an extension of time for witness statements. A number of things then happened, including the immediate judgment application. We are where we are, but technically that court order hasn't been varied to the original timetable, and we would ask that the court just release those dates. It's the dates for witness statements, expert reports, and the trial timetable, just because obviously technically we haven't complied with those.
Why don't you, or rather your junior, send Mather straight after this hearing? Mr. Anderson is here, I think, somewhere. Yes. Why doesn't he send Mather an email with what is needed by way of release, and then we will refix times for that when we see where we are after the February hearing?
I'm grateful, we'll do that.
Okay, so then Mather can incorporate that in the draft she's going to prepare and very kindly send to me. Mather, what have I missed? Is there anything else?
No, Judge, I think that's it.
Okay, Mr. Anderson will send you that, and by Wednesday the parties will also hopefully agree a timetable. And if you, Mather, are kind enough just to draw up a draft order, run it past me for approval, it can all be done this week.
Certainly, Judge.
Good. Anything else, Mr. Chief? I know you do elsewhere. Anything else?
No, can I just express my gratitude for your Lordship's accommodation on the timing of today?
Not a problem. Mr. Federighelli, thank you for coming in.
Thank you very much.
It's really much better that you were here than that nobody was representing the defendant, so I'm very grateful to you. Thank you.
And thank you for hearing me.
Of course. I look forward to seeing you both in February, and let's have a smooth run there with the directions we've agreed. Thank you very much. I get termination of the call.
Thank you very much.
Good day. Cheerio.